What form or criteria must be satisfied in justifying any particular application of technique of punishment? So, critics of utilitarian approach contend that the justification of punishments in terms of deterrence, prevention, and reform could be extended to justify punishing the innocent, providing where widely believed to be guilty in interest of deterrence, making a show of punishment without actually inflicting it, again deterrence, but this time on the cheap punishment in anticipation of the offense in interest of prevention or reform. These criticisms, if just, would surely be conclusive. So we've talked about the deterrence theory, wherein we give a very severe punishment so that the people, by the fear of getting punished, don't commit a crime, or preventive, so that in the first place only the people don't commit crimes. Reformative, wherein once the lesson is learned by the people, once the criminal is punished in such a way that the people learn their lesson, and and the criminal reforms himself and does not he himself does not repeat the punishment again. These criticisms, if just, would surely be conclusive. They are based, however, on a misconception of what the utilitarian theory is about. Punishment implies, in its primary sense, inflicting suffering only under specified conditions, of which one is that it must be a breach of a rule. So, what is punishment is that we inflict pain on somebody, but there is a condition for inflicting the pain. That the condition straightly supplies is that wherever there is a breach of a rule, of an established rule, only there you can give a punishment. Now, if we insist on this criterion for the word, punishment of the innocent is a logical impossibility, for by definition, suffering inflicted on the innocent or in anticipation of a breach of the rule cannot be punishment. Sorry. If we insist on this criterion for the word, punishment of the innocent is a logical impossibility, for by definition suffering on inflicted on the innocent. So when you read that one, above, when you read that it could be, this could be extended to justify punishing the innocent, you must have wondered that how come punishing the innocent works, because it is completely against the rule. If the person is innocent, if there's no breach of rule by the person, then the punishment just stands nullified, that the punishment is not possible there. It is not question of what is morally justified, but what is logically possible. So we're not talking about moral justification here, but we are talking about a logical possibility, that it is logically possible to punish an innocent. When we speak of punishing of innocent, we may mean pretending to punish in the sense of manufacturing evidence, or otherwise inputting guilt by knowing a man to be innocent. This would be treat to him as if he were guilty and involve the lying assertion that he was. It is objectionable, but not only as a lie, but also because it involves treating an innocent person differently from others without justification, or for an irrelevant reason, the reason offered being falsely grounded. So basically, punishing the innocent is kind of a deterrence theory, where we punish one person who hasn't done any wrong, but we punish the person so that, seeing the punishment of that person, the other people do not repeat the crime. We may mean by punish simply cause to suffer, that is guilty, not be imputed. This would be a secondary use of the word. In that case, it could not be said that as a matter of logical necessity, it is either impossible or wrong to punish the innocent. To imprison members of a subversive party, treating them in that respect like criminals through not offenses even charged, would not necessarily be immoral. Critics might describe it as punishing the innocent, but they would be illegitimately borrowing implications of the primary sense to attack a type of action to which these did not apply. So basically, there has not been a breach of rule, but there is, if somebody is doing something that can be accounted in the arena of punishment somewhere nearby, so we may cause them to suffer. Will not nearly punish them, but we may cause them to suffer, and that is a kind of, punishing the innocent, the people may say. It is only necessarily improper to punish the innocent if we pretend they are guilty. That is, if we accept all the primary usage criteria in any looser sense, there need be nothing wrong in any given case. For in exceptional conditions, it may be legitimate to deprive people of their liberty as part of a control technique, without reference to an offense. Similar arguments apply in the case of the issue of punishment. A utilitarian justification of punishment cannot be extended to cover lies or the making of distinctions where there are no relevant differences. It would be impossible merely to pretend to punish every criminal, and unless a relevant criterion could be found, there could be no grounds for treating some differently from others. So, of course, unless and until there is a breach of rule, unless until there is some possibility or the other, we cannot just punish any other person, because that would be completely immoral. The short answer to the critics of utilitarian theory of punishment is that there are theories of punishment, not any sort of technique involving suffering. So, one thing is that they are punishment. They're not some way that we make somebody else suffer, we inflict pain on them, but they are punishment. And punishment is done for any wrong deed done. And there are different theories of punishment: the deterrence theory, the reformative theory, the preventive theory, the retributive theory. All of these theories aim at one thing, that the other people do not repeat the crime, other people do not do the crime, and the criminal himself or herself does not repeat the crime. We may now turn to the retributivist position itself. F. H. Bradley asserted the necessary connection of punishment and guilt. Punishment is punishment only where it is deserved. If punishment is inflicted for any other reason whatever than because it is merited by wrong, it is a gross immorality, a crying injustice, an abominable crime, and not what it pretends to be. So, of course, a punishment is only punishment where it is justified. If there is, punishment, if a person who hasn't done any crime is being punished for some reason, if a person who's not proven guilty yet and still he or she is being punished, or any other such case, there is not a breach of rule and still you're saying that the punishment is justified, then it is not punishment. And then also it is immoral. Now we must distinguish between legal and moral guilt. So when we talk about guilt also, so the aim of punishment is that the criminal feels that guilt within himself. Okay, and it is because of the guilt, and its guilt is not only in the sense of the emotion or feeling as in, but the guilt means any wrong done. If the necessary connection asserted is between punishment and legal guilt, then this is this definition of punishment, masquerading as a moral judgment. It would be more accurate to write punishment is punishment only when it is deserved, for the sentence is then about the use of a word, not about the rightness of the act. So, punishment is only punishment when it is deserved by the person. Okay, when the person has done some crime, a breach of rule, the person has done some wrong deeds, only then if the person is punished, it is punishment. Other than that, in any sense, even if you mistake somebody for being the criminal and that person is not actually the offender, even then the punishment is wrong. The infliction of suffering on a person is not only properly described as punishment if that person is guilty. The retributivist thesis therefore is not a moral doctrine but an account of the meaning of the word punishment. But this is not the only form of retributivist thesis. There are at least four possibilities. First is that guilt is a necessary condition of punishment. That is, guilt means, of course, the wrong done. So guilt is not only in this used in the sense of an emotion or a feeling here, but guilt means when there is a wrong deed done, like a breach of law. Second is the guilt is a necessary condition of punishment. So that guilt is a necessary condition of punishment. This is the position just examined. That guilt, the breach of a moral rule is a necessary condition of punishment. So then breach of law and breach of a moral law, there are two different things. For example, you may have promised your friend that you would help him or her do his or her homework. Okay, if you do not fulfill your promise, that would not be that would not be breach of a legal law but breach of a moral law. So morally you have done something wrong, and that is why, according to the retributivist theory, the punishment can be according to the breach conducted. That guilt is a sufficient condition of punishment. That means if the breach of law has been done, it is a sufficient condition. Only that is necessary. But that means it is a necessity, it has to be there, and only that has to be there. It's a sufficient condition. We don't need any other reasons for somebody to punish the offender. And that guilt, that is the moral guilt, is also is also a sufficient reason, sufficient condition. We don't need extra reasons to provide why are we punishing the person. Position 3 is not logically necessary, for it does not follow from the definition of punishment. We cannot punish where there has been no breach, but we can and often do let off with a caution where there has. Other conditions besides guilt may have to be satisfied before punishment is wholly justified in a given case. The introduction in second and fourth of moral guilt puts a new complexion on retributive theory. A person who is morally guilty deserves blame, and the conditions of blameworthiness could be listed. But it is in no sense necessary that a person who is blameworthy should also be punishable. So, when talking about moral guilt, if we look at the definition of punishment, according to the retributivist theory, now there is another kind of guilt introduced, and that is the moral guilt. Before that, not before that, but in other theories, punishment is only in the sense of a breach of law, a legal law. So now there comes another criticism in retributivist theory, that okay, if a person is morally guilty, then maybe we can blame the person, but punishing the person, how much right is that? We may blame liars, but unless, example, they make false tax returns or lied to a court of law, we should not feel bound to punish them. So, if a person is lying, if, as I gave you the example of not fulfilling your promise, or even if the example of lying, so if a person is lying, you can blame the person that okay, you are a liar, but you cannot punish the person legally because there's no legal breach. There's no breach of legal rule that lying is illegal. But if the person is lying in returning the taxes that the person is filing income tax returns and taxes, and the person is saying he doesn't, the person doesn't do that, that is when the lie can be punished. Or when the person is lying in a court of law, only then can the person be punished. If the conditions of blameworthiness cannot be assimilated completely to the conditions for punishment, moral guilt cannot be a sufficient condition for punishment. Position 2 might be supported in two ways. A prima facie moral duty to obey a law may yield, in the case of immoral law, to a stronger duty. A breach of law would not then entail moral guilt, and we should question the justice of the punishment. So before this, right now we've already discussed that there's one criticism that when there is the involvement of when there is the presence of moral guilt, the person may be blameworthy, but punishing the person may not be really appropriate according to criticism to the retributive theory. Now, a prima facie moral duty to obey law may yield, in the case of an immoral law, to stronger duty. A breach of law would not then entail moral guilt. So, when there is a breach of law, it is not necessary that it is always accompanied by a moral guilt. Certain conditions like unavoidable ignorance or mistake of fact, lunacy, infancy, and irresistible duress would exonerate from blame. Certain conditions like unavoidable ignorance or mistake of fact, lunacy, infancy, and irresistible duress would exonerate from blame. Offences committed under these conditions should not be punishable and are not in fact punished, though the deterrent effects of the punish would be no less in these cases than in others. Therefore, in a negative sense at least, the criteria for blameworthiness must be satisfied if necessary conditions for punishment are to be satisfied. Punishment is retribution for such moral lapses as the law recognizes. So basically, how the blameworthiness, when we play how we blame a person when there is a moral breach done by the person, there's a moral guilt accompanied by the offense, that is when the person is liable for blaming but not really liable for punishment. So for the blameworthiness, there is no necessity of a punishment. So there is no necessity that a person is punished, should be punished whenever there is blameworthiness, whenever the person is blameworthiness. But if the person has to be punished, is the person if the person deserve punishment, there has to be blameworthiness. So you see that for one there is not the need of other. So when we talk about a moral breach, there is no need for a legal breach, because even without that we can blame the person, blameworthiness is there. But in case of a legal breach, there has to be the blameworthiness portion accompanied with it. The first argument might be met in two ways. From the judge's standpoint, so long as he continued in office, it would be his duty to enforce the law, whatever his opinion of it. For him, at least, the absence of moral guilt would not be a bar to punishment. So even if in such a case where an offense has been committed, there is a legal guilt, that is a legal breach of law or offense done by the offender, but if the moral guilt is not there, that doesn't mean that the judge can punish or cannot punish. A judge's decision is solely based on the breach of a legal rule, and solely based on the punishment according to the offense done. So whatever his opinion is, he may not strictly punish strictly punish an offender just because the offender is not showing any guilt. According to the judge, according to the rules and regulations, the judge has to punish the person according to the offense conducted. For him, at least, the absence of moral guilt would not be a bar to punishment. Secondly, criticism of a rule is only indirectly criticism of the justice of a punishment inflicted on the breach of it. The utilitarian could argue that a law is itself mischievous in Bentham's sense of cannot justify the further mischief of punishment. No good can come of it in any way. This is not, therefore, a defense of retributive theory of punishment, so as much as a statement of condition that a rule must satisfy if punishment is properly attached to it. So when we talk about a moral guilt and a legal guilt, the retributive theory states that there are four conditions according to the retributive theory, and that is, first is that the breach of law has to be there, it's a necessary condition, and the breach of law is a sufficient condition. Again, the moral guilt is a necessary condition and the moral guilt is a sufficient condition. So when we talk about a moral guilt, it is not necessary that we include the punishment in a moral guilt, because blameworthiness, by blameworthiness we mean we're not actually punishing the person, but we can blame him that he has done something morally wrong. Apart from that causing any suffering, any pain, just because he has conducted a moral breach of law, breach of moral law is not appropriate according to a moral guilt. Okay, but when it comes to breach of a legal law, just blaming the person, just telling the person that the person has done something wrong does not suffice. So you have to accompany it with a punishment, some cause of unpleasantness and suffering, as according to the definition of punishment that we have read. The second argument, B, is inconclusive. If the technique of punishment operates primarily by deterrence, it can serve its purpose only in respect of deliberate acts. No act committed under any of the above conditions would be deliberate. Now, now the B part says that certain conditions like unavoidable ignorance, mistake, lunacy, such conditions cannot be punished. Okay, so according to B, then everything would be completely inconclusive. Many of the arguments, many of the punishments would be, or many of the offenses would be inconclusive, because if the thing is, if the offender is, let's say, a juvenile, a lunatic person, or whatsoever, then the offense is not really considered an offense. But then that would not be correct, because uh, you know तो अगर अपन इस वाली आर्ग्यूमेंट की बात करें कि ऐसे केसेस वेयर देयर इज ल्यूनेसी, देयर इज इन्फेंसी, देयर इज ignorance or that part, in that manner, then more than half of the punishments would be deemed just wrong, they would be deemed inconclusive. Okay, so there has to be a way, okay, in respect of deliberate acts. So, if the technique of punishment operates primarily by deterrence, it can serve its purpose only in respect of deliberate acts, wherein there is an act that was done deliberately, that was done with the intention of doing that offense. Okay, without that intention, if the act is done, if it was not deliberate, it was by mistake that has happened, then in that case, there would be certain different conditions for punishment. Consequently, to punish in Consequently, to punish in such cases would be a pointless mischief. In any case, because some of the conditions for blame and punishment coincide, it does not follow that the satisfaction of the former is a necessary condition for the satisfaction of the later. I shall return to this point later in the relation to motive. So, of the four possible interpretations of retributivist relation of guilt to punishment, it is the first only whereby guilt in law is a necessary condition for punishment, that is completely persuasive. Okay, and this is precisely because it is a definition and not a justification. Consequently, it did not conflict with a utilitarian view. So the four means of retributive punishment, of the four, only the first one, that is guilt when there is a breach of law, it is only a necessary condition of punishment. That is the only way that we can punish. Other than that, the other three are also the conditions, but they are not really necessary, and they are not really interpretable as such. For a utilitarian to require for every case of punishment that it justified in terms of preventing more mischief than it causes would be to miss the point of punishment and as an institution. So according to the utilitarian view, it would ask for that punishment should be given only according to the offense committed. That means the degree of the offense committed should be the degree of the punishment. Okay, but then it will, according to the retributivist view, it will completely disregard the whole institution of punishment. Indeed, any rule would be pointless if every decision still be required to justify it in the light of its expected consequences. So whatever rule we are saying that punishment should be given only in the case of breach of law, when there is a breach of rule, so that every rule stands nullified, no rule will be useful then, because in that case, in a utilitarian view, according to the utilitarian view, every offense had to be justified again and again. It would be have to be justified again and again. The punishment should be according to those consequences. This is particularly true of penal rules, for the effectiveness of punishment as a deterrent depends on its regular application, save under conditions sufficiently well understood for them not to constitute a source of uncertainty. Legal guilt once established, then the initial utilitarian presumption against causing deliberate suffering has been overcome, and a case for a penalty has been made out. but it may still be defeated, for since guilt is not a sufficient condition, there may well be other relevant considerations. The following formal criterion may be postulated, however, which any consideration must satisfy, namely that to recognize it as general ground for waiving the penalty would not involve an otherwise avoidable mischief to society greater than the mischief of punishing the offender. Okay, so in particularly true for penal rules, that utilitarian view cannot be really employed as such, because the whole institution of punishment, the whole reason of punishment will be then nullified, and the effectiveness of punishment as a deterrent, so that the punishment are not repeated, so that the other others who would want to commit an offense, they would not do that. So that effectiveness of punishment would be completely nullified, because then the punishment will not be regularly applied. Every case, for every offense committed, you will have to again and again justify why it is an offense in the first place, what are the consequences of that offense, and what is the punishment that you have subjected to the offense according to the consequences created. So it will not be as such effective and regular when it comes to punishment, and the possible outcomes that we want out of punishment, that it should be deterrent or it should be retributivist in its approach, that outcome will not be achieved if we are applying the utilitarian view. One of the criticism levels against utilitarianism is that by relating the justification of punishment to its expected consequences rather than to the crime itself, it would justify penalties divorced from the relative seriousness of crimes, permitting severe penalties for trivial offences if that were the only way to reduce their number. So there is one criticism that can be said against utilitarianism, that is, if we relate the justification of a punishment, that is, if we are giving the punishment only according to the crime committed and the consequences, and not only according to the degree of the offense, that is also wrong, according to the consequence that it has. That means that even if somebody is doing a very serious offense or committing a very very serious or a very big crime, even then according to the utilitarian view, the crime can be completely neglected, because possible that the offense for sorry possible for the consequence that it created is not really up to it. So utilitarian view gives the punishment only according to the consequences. Now let's say, for example, I've given this example before, that there is an orphan who is murdered by somebody. Now this is a very huge crime, a very huge and a very serious offense, but let's say the consequence as such, now this is a very very random example, and it has lot of applications in it, there are a lot of particulars in when we apply the utilitarian view, but for a very general and simple understanding that I'm stating here, that for example, if an orphan is being has been murdered by a criminal, that criminal still won't be punished according to the consequence, because the consequence was not as such, because the murder of the offense or the death of the orphan would not really impact anybody, the consequence would be null. So that is why sometimes it is possible that in utilitarian view, very serious crimes are left you know unpunished, and sometimes very very small or very very trivial offenses may be punished to a greater degree only because of the consequence. A serious but easily detected crime might warrant lesser penalties than a minor but secret one, this conclusion being intolerable. So it is possible that a lesser penalty or a lesser serious or a serious offense less serious offense can sometime give birth to a very serious punishment, because the consequence may be more. This conclusion being intolerable, the retributivist contends that to escape it we must seek the measure of the penalty in the crime itself according to the degree of wickedness involving in committing it. So that is why, according to the utilitarian view, only the consequence is seen, but according to the retributivist view, we see the punishment, the seriousness of the offense committed. Again, I distinguish the justification of rules from the justification of particular applications. To ask how much punishment is appropriate to a given offense is ambiguous. It may refer either to the punishment allotted by a rule to a class of acts or to a particular award for a given act. Within that class, the distinction is pointed by the practice of laying down only maximum penalties in the rule, leaving particular determinations to judicial discretion. Now, what formal criteria must be satisfied in justifying the degrees of punishment attached to different classes of offense? The only case, said Kant, in which the offender cannot complain that he is being treated unjustly is if his crime recoils upon himself and he suffers what he has inflicted on other, if not in a literal sense, at any rate according to the spirit of the law. So the only case जहाँ पे offender अपने जो उसके साथ बुरा हुआ है, जो उसके साथ ऑफेंस हुआ है, उसके लिए द ऑफेंडर कैन नॉट क्लेम any punishment or cannot claim any compensation is when the offender's act recoils upon himself. Okay, that when the offender has said something wrong, has done something wrong, and the consequence of the wrong action is being suffered by the person himself or herself. Only in that case the person cannot claim a um, punishment or a compensation for the crime. It is only the right of requital which can fix definitely the quality and quantity of the punishment. This is the most extreme retributive position. Its essential weakness is present, however, in more moderate attempts to seek the determinants of punishment exclusively in the offense itself. If retaliatory punishment is not to be effected in a literal sense, which might well be intolerably cruel and in some cases physically impossible, but rather according to the spirit of the law, it involves a sort of arithmetical equation of suffering as impracticable as the hedonistic calculus. Suffering of one sort cannot be equated with another, though it may be possible to prefer one to another or to be indifferent as between one another. I can certainly say that I would rather see A suffer in one way than B in other, or that there is really nothing to choose between the two. But this is quite different from saying that A ought to be made to suffer in exactly the same degree as B, whom he has injured, for this involves not a preference enunciated by some third person, but a quantitative comparison of the sufferings of two different people treated as objective facts. And there is no way of making this comparison even though one external features of their suffering may be identical. So, now when we say that the retaliatory punishment is not to be effected, but rather according to the spirit of law, it involves a sort of arithmetical equation. So, now we are talking about, in a sense, that for example, there is an offender who has committed an offense, and in some way or the other, the consequences of that offense is being uh, taken by or is being suffered by the offender himself. In that case, what will be the condition of the punishment? For example, in the cases of suicide. In the case of a suicide, if a person commits suicide, the offender and the person suffering from the offense are both the same person. But then, does that mean, देखिए punishment का general rule and general meaning ये होता है कि the other person, the one who is offended, should suffer according to, you know, the one who has offended. So the offender should suffer according to the offended. That is the rule of the punishment, or that is why we are punishing, that as much suffering you have given to one person, the suffering should be given to you. So in that case, what if the person who has done the offense, who has committed the offense, is the person who is suffering it? In that case, then is the person liable to punishment? So according to the spirit of law, yes, the person is liable to punishment, because you cannot really compare both the sufferings in that case. And in any case, an offense has been committed. That is what is the heart of retributive punishment. तो retributive punishment को देने का criteria that we see is that the seriousness of the offense and the punishment. Utilitarian view में we do according to the suffering or the consequence, but in retributive punishment we see what is the offense done, what is the crime done, and the punishment is given according to the seriousness of the crime and not according to the suffering or not according to the consequence that it has produced. And that is why in a case that may be कि जो offender है उसी को उस offense के consequences झेलने पड़ रहे हैं, even in that case the offender has to be punished, because according to the spirit of law and according to the retributive punishment, a crime has been committed and the punishment of the crime has to be given. It is even more evidently impossible when the suffering of one is occasioned by, say, blackmail and the other by imprisonment. And also, we cannot really compare the suffering of two people. Maybe the same degree of punishment has been, let's say, inflicted upon two people, but still, हम ये नहीं बोल सकते कि, for example, कि A has beaten B. So now let's beat A also, so that the same suffering is being inflicted upon A. That is not really possible, because in such a case the suffering has been inflicted by a third person, not B himself. So the punishment is inflicted by a third person who has nothing to do with the offense or the suffering of the offense. So in that case, you cannot really equate the suffering. You cannot really say that okay, the same suffering has been inflicted and now I've got, because anyway suffering has been inflicted on B, so that suffering cannot be undone. It cannot be undone. So that is why, that is the reason that even in the case of retaliatory offenses, wherein the offender himself is suffering the consequences of his or her actions, even in that case, according to the retributive punishment, the person or the offender has to be punished, because in the spirit of law, a crime has been committed. Whoever bears the consequence is a secondary thing. In the primary thing, a offense has been committed, and that is why the offense has to be punished. The difficulty remains in the compromise between a utilitarian and retaliatory position attempted by W.D. Ross. While admitting that the legislator must consider the deterrent ends of punishment in assessing penalties, he maintains that the injury inflicted by the criminal sets an upper limit to the injury that can legitimately be inflicted on him. So, according to W.D. Ross, the injury that the criminal does, it sets a limit. It sets a upper limit, because the punishment cannot be more than that. The punishment has to be under the injuries done by the criminal. You cannot, for example, the crime that has been committed is that of a petty thievery. Okay, a person has stolen something from a shop. So then accordingly, the punishment cannot be more than the injury done by the criminal. So the criminal sets an upper limit, so you cannot punish above that limit. For he has lost his prima facie rights to life, liberty, property only insofar as these rested on an explicit or implicit undertaking to respect the corresponding rights in others, and insofar as he has failed to respect those rights. But how are we to make this equation between the rights invaded and consequently sacrificed and the amount of suffering so justified, unless there is already available on scale or rule or fixing the relation? But then how is the scale to be justified? So how can you say that okay, according that every person has a right to live, life, right to property, right to liberty, everything, and the criminal, when the criminal does an offense, commits a crime, it's a crime or an offense, the criminal is basically invading those rights, is not giving the other person the right to all of these things. That means there is an invasion of the rights done. So how can you justify a scale or a relation between the right and the offense and the punishment that is done? J.T. Mabbitt admits there can be no direct relation between offense and penalty, but seeks by comparing one crime with another to make an estimate of the penalty is relatively appropriate. So you cannot really compare the penalty and the offense, because anyhow the suffering has been taken by the other party. So you cannot undo the suffering. The suffering has already been done. So there cannot be a direct relation between the offense and the penalty, but you can always compare the two. We can grade crimes in a rough scale and penalties in a rough scale and keep our heaviest penalties for what we are socially the most serious wrongs, regardless of whether these penalties are exactly what deterrence would require. But what are we to understand by socially the most serious wrongs? So we can say the penalties. So we can scale the penalties on a rough scale from 0 to 10. We can scale the crime, or not only on a scale to 0 to 10, but on any scale as such. So we can rate the penalties and we can rate the crimes, and then accordingly the most rated penalties are to be inflicted on the most rated crime or offense done. But then, how can you classify the most serious social wrongs? How can you say that, okay, this crime is the most serious and this crime is the less serious? On the one hand, they might be those that shock us most deeply. So we can say that the crimes that shock us more deeply are more serious. We could then construct a shock scale and punish accordingly. So then the punishment can be according to the shock scale. If we say that the crime that shocks us most is the most serious wrong done, then the punishment can also be according to the shock scale, that the one punishment that inflicts the most shock on the person or the offender, that is the most serious punishment. There are some shocking acts, however, that we should not want to punish at all. Example, some sexual offenses against morality. At the same time, we should be hard to put it to know that what penalties to attach to new offenses against, say, currency control regulations, where the initial shock reaction is either negligible because the rule is unsupported by a specific rule of conventional morality, or where it is of standard mild variety accompanying any offense against the law as such, irrespective of its particular quality. But then, what about the offenses which cannot be put on a shock scale or cannot be penalized as such? For example, the cases of sexual offenses. So how do you really put it on a shock scale what the person of the the sexually offended has gone through? What shock has the sexually offended gone through, and how can you inflict that punishment onto the offender? Or what about some new offenses जिसके बारे में there is no shock scale until now? So like for example currency regulation, currency control, like for example the cryptocurrencies are coming on. So what about some new offenses, for example the creation of some new currency altogether? So what about the offenses of such there is no shock scale, there is no shock until now, proven until now. Maybe there are so many offenses jiska shock is inflicted upon years later. So what about those offenses then? On the other hand, the most serious wrongs may be simply those we are least ready to tolerate. So one can be according to the shock scale, or second criteria that can be used to judge the serious wrongs can be the one that we are least prepared to tolerate, that we don't anyway want to tolerate. That, however, would be to introduce utilitarian conditions into a criteria of seriousness. For to say that we are not prepared to tolerate an offense is to say that we should not feel justified in imposing heavy penalties to deter people from committing it. But in making deterrent consideration secondary to degree of seriousness, Mr. Babbitt implicitly excludes this interpretation. So when we say that the offense or the seriousness of the offense or the wrong of the offense should be according to the one that we are not at all ready to tolerate, then it will include a utilitarian view that we are not ready to tolerate. The consequence of it is something that we are not ready to tolerate, and that is why it includes a little utilitarian view in it. The retributivist difficulties arise from seeking the measure of the penalty in the crime without first assuming a scale or a rule relating the two. So, according to the retributivist view, we only see the measure of the penalty in the crime. Given the scale, any given penalty would require justification in terms of it, but the scale itself, like any rule, must in the end be justified in utilitarian terms. So, the scale that we are using, the criteria that we are using to justify or to classify the seriousness of the crime committed, that scale at the end has to be somehow utilitarian in its approach. इट्स रिमेन्स टू बी सीन यूटिलिटेरियन इन द केस कि जैसे हमने शॉक स्केल का यूज़ कर रहे हैं कि जितना शॉक लगा फिर उतना ही हम उसका पेनल्टी लेंगे. सो देन ये जो जितना शॉक हमें मिला है उतना ही शॉक की हमें पनिशमेंट इन्फ्लिक्ट करेंगे. दैट इज़ अगेन ए यूटिलिटेरियन व्यू. It remains to be seen whether this necessarily opens the way to severe penalties for trivial offences. तो अभी तक इट हैज़ नॉट बीन रियली जस्टिफाइड कि अगर हम ये यूटिलिटेरियन अप्रोच यूज़ करेंगे तो क्या इसमें ट्रिवियल ऑफेंसेस के लिए, छोटे मोटे ऑफेंसेस के लिए भी सीरियस पेनल्टीज इन्फ्लिक्ट हो सकती है. For the utilitarian, arguing in deterrent terms, it is the threat rather than the punishment itself which is primary. तो इट इज़ द थ्रेट रादर देन द पनिशमेंट. यूटिलिटेरियन अप्रोच में ये थ्रेट होना कि आपको पनिशमेंट मिलेगी, ये ही कहीं ना कहीं बहुत हो जाता है. कुड वी रिलाई ऑन द थ्रेट बीइंग कम्प्लीटली इफेक्टिव? क्या हम ये कह सकते हैं कि जो थ्रेट है, ये डर है कि पनिशमेंट मिलेगा, यही इफेक्टिव हो सकता है? देयर कुड बी नो ऑब्जेक्शन टू द डेथ पेनल्टी फॉर एवरी ऑफेंस सिंस एक्स हाइपोथेसी इट वुड नेवर बी इन्फ्लिक्टेड. So that means कि सिर्फ ये threat मिलना that you will be, you will have to die because of any offense that you commit, so that would be only enough and you will never have to inflict any punishment on anybody. Unhappily, we must reckon to inflict some penalties, for there will always be some offenders no matter what the threatened punishment. So unfortunately this cannot be done, that no matter how effective the threat is, still you will have to inflict the punishment in some cases or the other, because there will always be offenders जो कि threat से नहीं डर रहे हैं. We must suppose then for every class of crime a scale of possible penalties, to each of which corresponds a probable number of offensive and therefore of occasions for punishment, the number probably diminishing as the severity increases. Ultimately, though, according to the severity of the punishment increases, the number of crime is expected to go low. Ultimately, however, we should almost certainly arrive at a hard core of undeterables. We should then choose for each class of offence that penalty at which the marginal increment of mischief inflicted on offenders would be just preferable to the extra mischief from the communities protected by this increment of punishment. To inflict any heavier penalty would do more harm than it would prevent. So, to inflict any heavier penalty would do more harm. You are inflicting more penalty than the offense or crime committed, that would be even wrong. So, that is not complete, that is not at all justified. This involves not a quasi quantitative comparison of suffering by the community and the offender, but only a preference. We might say something like this: to increase the penalty for parking offences to life imprisonment would reduce congestion on the roads. Nevertheless, the inconvenience of a large number of offences would not be serious enough to justify disregarding in so great a measure the prima facie case for liberty, even of a very few offenders. With blackmail or murder, the possibility of averting further instances defeats to a far greater extent the claims of the offender. One parking offense more or less is not of great moment, one murder more or less is. तो हम ये नहीं कर सकते हैं कि हम एक छोटे से ऑफेंस के लिए कोई बहुत बड़ी पनिशमेंट इन्फ्लिक्ट कर लें। मान लीजिए कि कोई पार्किंग ऑफेंस हुआ है, किसी ने गलत जगह पर गाड़ी पार्क कर दी है, गलत तरीके से गाड़ी पार्क कर दी है, उस ऑफेंस के लिए हम कोई बहुत बड़ी पनिशमेंट नहीं दे सकते हैं, ठीक है, बिकॉज उसके कॉन्सिक्वेंसेज जो होंगे, जो रोल आउट होंगे, दैट वुड नॉट बी अप्रोप्रिएट देन, क्योंकि एक बहुत ही छोटा सा ऑफेंस कमिट हो रहा है और उसका जो पनिशमेंट और पेनल्टी मिली दैट इज़ वे बिग, कि मान लीजिए डेथ पेनल्टी उसके लिए दे रहे हैं, तो दैट कैन नॉट बी असाइंड बिकॉज वो इक्वेशन इज़ नॉट रियली इक्वेटिंग, इज़ नॉट रियली इक्वल। सिमिलरली अगर हम मर्डर की बात करें, सो मर्डर इज़ अ वेरी सीरियस ऑफेंस एंड नीड्स अ वेरी सीरियस पेनल्टी। सो यू नो, nevertheless the inconvenience of a large number of offences would not be serious enough. तो इस वजह से then everybody would see कि यार, if for a parking offence also you are getting a death penalty and for a murder also you are getting a death penalty, मतलब murder is not that big of a crime because penalty for both of them is very big. तो इस वजह से the अगर हम ये करेंगे कि पार्किंग ऑफेंस के लिए छोटी पेनल्टी एंड मर्डर के लिए बड़ी पेनल्टी, देन एवरीबडी then you will view the penalty or the crime of murder as to be something very serious and something very very wrong, because the penalty of it is greater than other trivial penalties for offenses done. In retaliatory theory, we are asked to estimate the damage done by the crime and to inflict just that amount on the criminal. Here, we are required only to choose between one combination of circumstances and another. The choice may not always be easy, but it is not impossible or even unusual. For we are well accustomed to choosing between things incapable of quantitative comparison. What is impossible is to assess that what man has suffered from blackmail and then to impose its equivalent on the blackmailer in terms of a prison sentence. तो मान लीजिए ऐसा कोई कॉन्सिक्वेंस जो रिटेलिएटरी है, ठीक है, जिसका जो सफरिंग हो रही है, मतलब वो कहीं ना कहीं उसी के ऊपर हो रही है, तो ऐसे केसेस में इन रिटेलिएटरी थ्योरी में हम देखिए, ये बात तो है कि वी के नॉट, देर आर सो मेनी थिंग्स दैट हम जो क्वान्टिटेटिवली कंपेयर नहीं कर सकते हैं, सो वी असेस देम ऑन अ क्वालिटेटिव बेसिस, और वो क्या क्वालिटी होगी, दैन देर आर सो मेनी डिफरेंट ऑप्शंस एंड देर आर सो मेनी डिफरेंट वेज जिसमें हम क्वालिटेटिवली असेस कर सकते हैं, बिकॉज देर कैन बी मेनी डिफरेंट क्वालिटीज़ जिसके बेसिस पे हम असेस कर सकते हैं. सो what one man has suffered from blackmail and then to impose its equivalent on the blackmailer in terms of a prison sentence is something that is impossible. तो अगर एक इंसान को ब्लैकमेल करा गया है तो हम कैसे उस ब्लैकमेल के ऑफेंस को पिनलाइज कर सकते हैं ऑन द ब्लैकमेलर? हाउ कैन वी इन्फ्लिक्ट द सेम डिग्री ऑफ पनिशमेंट ऑन द ब्लैकमेलर जो कि उसने ब्लैकमेल करने वाले के ऊपर, जो ब्लैकमेल हो रहा है उसके ऊपर करी है? The difference between a prescription and a description. To say, as I do above, that the right penalty is that at which the marginal increment of mischief inflicted is just preferable to the mischief thereby avoided, is to invite the critic to choose one state of affairs rather than another. But to say that the penalty should be equal the suffering of the victim of the crime is to invite him to prescribe a course dependent not on his own preferences but on a factual comparison of incomparables on an equation of objective conditions. The utilitarian case, as I have now put it, is not open to objection that it would justify serious penalties for trivial offences. But to call that offense trivial is to say that we care less if one is committed than in others. तो अगर हम किसी offense को कह रहे हैं कि ये बहुत ही trivial सा offense है, मतलब हम उस offense के बारे में इतना care ही नहीं करें, that is wrong. हर offense should be taken seriously. Maybe the penalty that is inflicted upon according to the offense वो trivial हो सकती है. That is, we should be unwilling to inflict so much suffering to prevent it as to prevent others. कि मतलब हम लोग इतने willing नहीं है उसको penalize करने के लिए जितने हम बाकी offenses को होंगे. Relatively serious crimes are those relatively less tolerable. That is, we prefer to inflict severer penalties rather than to suffer additional offenses. तो जब हम सीरियस क्राइम्स की बात कर रहे हैं, वो सीरियस क्राइम्स वो होते हैं जिनको हम कम टॉलरेट करना चाहते हैं, जो इतने ज़्यादा टॉलरेबल नहीं है, एंड दैट इज़ जिस पे हम सीवियर पेनल्टी इन्फ्लिक्ट करना प्रेफर करेंगे इंस्टेड ऑफ सफरिंग मोर. तो अगर पहले से ही हम किसी क्राइम और ऑफेंस के ऊपर एक सीरियस पेनल्टी लगा देंगे, दैट मीन्स उसके होने के चांसेस वुड बी रिड्यूस्ड सिग्निफिकेंटली. Some penalties we are willing to inflict whatever their deterrent force. We are less ready to torture offenders and to suffer their offenses. And there are people who would rather risk murderers than inflict the death penalty, even opposing it to be the unique deterrent. तो डेफिनेटली हम लोग इतने इंटरेस्टेड नहीं है किसी क्रिमिनल को टॉर्चर करने में, रैदर देन हम लोग ज़्यादा इंटरेस्टेड है कि हम उसके कॉन्सिक्वेंसेस, वो ऑफेंसेस की वजह से हमें पहली जगह पर ये सफ़र ना करना पड़े. और फिर लोग हैं जो कि रैदर रिस्क मर्डर्स दैन इन्फ्लिक्ट द to kill, they say, is absolutely wrong. Now, this may mean only that no circumstances are imaginable in which its probable consequences would make it right, that is, in which the mischief done would not outweigh the mischief prevented. तो ऐसे कोई कॉन्सिक्वेंसेज नहीं. अगर अगर हम किलिंग की बात करें तो किलिंग किसी भी केस में ज़्यादा सही नहीं हो सकता है. क्यों? क्योंकि हमारा मेन एम है कि वो मिसचिफ हो ही ना. उसके होने के बाद, ऑफेंस के होने के बाद उसको पनिश करना इज़ नॉट आर मेन एम. आर मेन एम है कि ये है कि हमें उसको प्रिवेंट करना है पहले ही केस में. तो हमारा जो पनिशमेंट है दैट शुड बी इन सच अ वे कि हम लोग उसको प्रिवेंट कर सके जितनी हो सके. Not that it could never be right, only that in any imaginable conditions it would not be. This would not exclude justification by consequences and is therefore compatible with view of punishment I am advancing. On the other hand, if the absolutist denies together the relevance of consequences, he is making an ultimate judgment for which, in the nature of the case, justification can neither be sought nor offered and which is therefore undiscussable. तो अगर हम दूसरे केस पे बात करें कि अगर हम उसको क्योंकि हम हमारा मेन गोल जो है उसको प्रिवेंट करना है, और अगर हम ये कहें कि एक एब्सोल्यूटिस्ट है जो उसको डिनाई कर दे कि पनिशमेंट देने का कोई फ़ायदा ही नहीं है, अगर फिर भी क्राइम हो रहा है तो पनिशमेंट देना इज़ बेफिजूल, तो दैट इज़ समथिंग दैट इज़ आउट ऑफ कॉन्टेक्स्ट. इसको डिस्कस करना ही इज़ कम्प्लीटली वर्थलेस. I conclude from this discussion that any justification for the nature and degree of punishment attached to a given class of offence must satisfy the following formal criteria. तो अगर हम किसी ऑफेंस को पनिश कर रहे हैं उसके कुछ क्राइटेरिया उस पनिशमेंट को फॉलो करने चाहिए. फर्स्ट, that the marginal increment of mischief inflicted should be preferable to the mischief avoided by fixing that penalty rather than one slightly lower. Assuming that the advantages of punishment derive mainly from upholding rules, this means that the conformity secured weighed against the suffering inflicted should be preferable to a lower level of conformity weighed against the suffering inflicted by imposing a lesser penalty. तो हमारा जो पेनल्टी है वो इतना होना चाहिए कि जितना हमने मिसचीफ किया है उसके अकॉर्डिंग, उसके स्केल में होना चाहिए, उसके नीचे नहीं होना चाहिए और ना उसके ऊपर होना चाहिए. मतलब जो जितनी उसकी सीरियसनेस करी हुई है उसके अकॉर्डिंग होनी चाहिए. और बेसिकली पनिशमेंट का एडवांटेज यही होता है कि हम अज्यूम कर रहे हैं कि लोग ज़्यादा से ज़्यादा रूल्स को फॉलो करें. ये पनिशमेंट का एडवांटेज है कि पनिशमेंट अगर आप इन्फ्लिक्ट करो मतलब लोग जो है बाकी लोग जो पनिशमेंट से बचना चाहेंगे वो रूल्स को अपहोल्ड करेंगे. इसका मतलब कि suffering inflicted should be to a lower level of conformity weighed against this inflicted by imposing a lesser penalty. Okay. What formal criteria must be satisfied in justifying the particular penalty awarded to a given offender? Two men guilty of what is technically the same offence, that is, one who are breaking the rule, are not necessarily punished alike. So दो मैन जिन्होंने सेम जो ऑफेंस कमिट किया है उनको एक जैसे नहीं पनिशमेंट मिलती है, क्योंकि दिस कुड बी जस्टिफाइड ओनली बाय रेफरेंस टू रेलेवेंट क्राइटेरिया अदर दैन सिंपल गिल्ट बाय विच देयर केसेस आर डिस्टिंग्विश्ड. प्रोवोकेशन, टेम्पटेशन, ड्यूरेस एंड अ क्लीन रिकॉर्ड मे ऑल मेक अ डिफरेंस. तो दो क्रिमिनल्स को ज़रूरी नहीं हम सेम तरीके से पनिश करें, क्योंकि उसमें हम बहुत सारे और फैक्टर्स देखते हैं, जैसे प्रोवोकेशन, क्या रीजंस थी जिस वजह से वो क्राइम करा गया है. टेम्पटेशन, ड्यूरेस कि उस क्रिमिनल ने कितना उसको सफ़र किया, उसके ऊपर कितना उस चीज़ का इफेक्ट हुआ है. क्लीन रिकॉर्ड कि क्या वो एक रिपीटेड ऑफेंडर है या फिर वो फर्स्ट टाइम ऑफेंडर है. ये आर रेलिवेंट टू द डिटर्मिनेशन ऑफ ब्लेम. फ्रॉम दीज कंसिडरेशन अराइज टू पॉसिबल ऑब्जेक्शंस टू द व्यू आई एम एडवांसिंग. अब इसके ऊपर हम दो पॉसिबल ऑब्जेक्शंस देखते हैं. सो इट इज़ कंसिस्टेंट विद द यूटिलिटेरियन. Is it consistent with utilitarianism that in determining the sentence we should look to particular conditions of the crime rather than to the consequences of the पेनल्टी। तो क्या ये यूटिलिटेरियन व्यू के अकॉर्डिंग कंसिस्टेंट होगा कि अगर हम कंडीशंस ऑफ क्राइम पे ज़्यादा ध्यान दें इंस्टेड ऑफ द कॉन्सिक्वेंसेज इट प्रोड्यूस, कि अगर कोई क्राइम हुआ है वो किस वजह से हुआ है, किन कंडीशंस में हुआ है, क्या वो इतना बड़ा ऑफेंस है, मतलब मे बी हो सकता है दो क्रिमिनल्स ने सेम ऑफेंस करा है लेकिन फिर भी उसके कंडीशंस बहुत अलग हो सकते हैं। शुड वी नॉट लुक फॉरवर्ड टू द एग्जाम्पलरी एडवांटेजेस ऑफ द मैक्सिमम पेनल्टी रादर दैन द बैकवर्ड टू एक्सटेंचुएटिंग सर्कमस्टांसेस? सो what he is suggesting is that there is an objection that he is advancing to the utilitarian view, that instead of looking at the consequences you can also look at the circumstances in which the crime was done. Since we do look backwards and assess the penalty in the light of criteria also relevant to an assessment of blameworthiness, can we not say that men deserve punishment only in the measure that they deserve blame? So the punishment that they deserve is only according to the blame that they deserve. There are so many cases जहाँ पर होता है कि in revenge the crimes are committed because of revenge done, कि जो revenge हुए हैं उस वजह से crime की जा रही है, और मे बी कि किसी के साथ गलत हुआ है और उसका रिवेंज लेने के लिए उसके लिए उन्होंने क्राइम कमिट किया है। सो देन जितना वो ब्लेम डिज़र्व करते हैं उसके अकॉर्डिंग अगर हम उसको पनिश करें, आई थिंक अकॉर्डिंग टू द राइटर दैट वुड बी अ मोर अप्रोप्रिएट वे. As to a rule once accepted, there is no need to justify every application in terms of its consequences. Is it necessary to justify in utilitarian terms only the criteria of extenuation, not every application of them? Now, precisely because an offence has been committed under exceptional circumstances, leniency would not seriously weaken the threat, since offenders would expect similar leniency only in similar circumstances. तो ऐसा नहीं होगा कि अगर हम अकॉर्डिंग टू सर्कमस्टांसेस कि जिन सर्कमस्टांसेस में वो क्राइम कमिट हुआ है उसके अकॉर्डिंग अगर हम उनको पनिशमेंट देंगे तो इसका मतलब ये नहीं है कि लोग उससे डरेंगे नहीं, क्योंकि लोग समझेंगे कि ओके द पनिशमेंट इज़ अकॉर्डिंग टू, अगर हमें कम पनिशमेंट मिलेगी इफ़ वी आर इन सिमिलर सर्कमस्टांसेस, सो दे वुड सी दैट हाउ मच देयर ओन क्राइम इज़ जस्टिफाइड. Man would be unlikely to consider rationally the penal consequences of his act, given that the full measure of the penalty would be unjustifiable. As to B, while some criteria tend to mitigate both blame and punishment, the latter need not depend on the degree of the former. The question of motive is crucial. We generally regard a man as less blameworthy if he breaks a rule from the highest motives rather than selfishly or maliciously. A traitor from conscientious conviction may be blamed for wrongheadedness, but if we respect his integrity, we blame him less than a merely mercenary one. तो अगर हम देखें कि कोई ऐसा है कि हम उसकी इंटीग्रिटी को वो करते हैं कि फॉर एग्जांपल दैट वी जनरली रिगार्ड अ मैन लेस ब्लेमवर्दी इफ़ ही ब्रेक्स अ रूल फ्रॉम द हाईएस्ट मोटिव्स रादर दैन सेल्फिशली और मलिशियसली, कि वो अपने खुद के फ़ायदे के में ना देखते हुए और किसी और रीजंस की वजह से अगर उसकी इंटीग्रिटी में इंटैक्ट रखते हुए अगर वो कोई क्राइम कर रहा है तो ऐसे केस में दैट मैन इज़ रिस्पेक्टेड मोर, या उसके क्राइम जो है उसको ब्लेम कम किया जाता है बेसिकली. सो यहाँ पे एक थर्ड फैक्टर आ जाता है दैट कॉन्सिक्वेंस offense, and the third factor is blame, that how much is the criminal should be blamed. According to the blame we inflict the punishment. Honest motives will not always mitigate punishment. ज़रूरी नहीं है कि हर बार offense जो है वो dishonest motives के उसमें के कई बार honest motives also give birth to some crimes and offenses. It may be vital for the effectiveness of government that conscientiousness recalcitrants be deterred from action, but since strong moral convictions are often less amenable to threats than other motives, they could scarcely be admitted in such threats in cases in extenuation of punishment. On the other hand, if the mischief of the penalty needed for a high degree of conformity exceeds its advantages, it may be reasonable to give up punishing conscientiousness offenders altogether, provided they can be discerned from the facts. We can no longer punish conscientious objectors to military service, having found experience that they are rarely amenable to threats, that they are unsatisfactory soldiers if coerced, and that given a rigorous test of conscientiousness, their numbers are not likely to be so great as to impair the community purpose. The considerable overlapping of the factors tending to mitigate blame and punishment nevertheless demands explanation. तो या अगर हम blame के according भी देखें कि according to the blame we are inflicting a punishment, that also requires a lot of explanation, that also requires a lot of procedures to bring it to place. Morality and law are alike rule systems for controlling behavior. तो morality is a different thing and law is a different thing. We punish according to morality. कहीं ना कहीं अगर हम punishment according to blame दे रहे हैं तो उसमें कहीं ना कहीं morality या moral का perspective आ जाता है. But if we are punishing according to the offense done, that is according to the law, then it is a different thing. Since they are closely analogous as techniques for discouraging undesirable conduct by making its consequences in different ways disagreeable, the principles for avoiding them largely coincide. But it does not follow that because we usually also blame the man we punish, we should punish in the light of the criteria determining moral guilt. So ये ज़रूरी नहीं है हर बार कि हम लोग जिस मैन ने एक ऑफेंस कमिट किया उसको हम हर बार ब्लेम ही करें. कई बार कॉन्सिक्वेंसेस होते हैं कि लोगों को क्राइम करना पड़ता है. देर आर सो मेनी डिफरेंट केसेस फॉर सच. सो देन कई बार punishing them very heavily is not really the expected consequence. It does not follow that because we usually also blame the man we punish, we should punish in the light of the criteria determining moral guilt. Morality operates as a control not only by prescribing or prohibiting acts but also by conditioning character. तो morality में हम किसी का character भी judge करते हैं. Morality operates, we blame men for being bad tempered, we punish them only for assault. तो blame and punishment are two different things. Punishment only according to the offense committed, लेकिन blame हम उसके temperament के लिए भी करते हैं. Furthermore, punishment is administered through formal machinery of investigation, proof, conviction, sentence and execution. Blame by informal and personal procedures. So हम जब blame करते हैं, that is a very different thing, that is a very personal thing. And on the other hand, when we look at a punishment is according to proof, sentence, execution. Blame is according to the informal and the personal choices that has been made. To the extent that the techniques are analogous, they may be expected to employ their similar criteria, but the analogy cannot be pushed all away. So हम blame को completely disregard नहीं कर सकते हैं. It can be somewhere considered. सो ये रेट्रीब्यूटिविस्ट और यूटिलिटेरियन के बीच में जो क्वारल है, ये बेसिकली अबाउट प्रोसीजर ऑफ जस्टिफिकेशन है कि कैसे हम एक ऑफेंस को पनिश करें और हाउ द पनिशमेंट हैज़ टू बी डन इन जनरल और इन पर्टिकुलर, अबाउट द फॉर्मल क्राइटेरिया दैट टुगेदर फॉर्म अ स्कीमा टू विच एनी जस्टिफिकेशन मस्ट कन्फर्म. I have maintained that when what is wanted is a justification of a rule or an institution of punishment in general or of the scale of punishments assigned to different cases of offense, it must be sought in terms of net advantages gained or mischievous avoided. तो हमारा जो पनिशमेंट है उसमें हमें बहुत सारी डिफरेंट चीज़ों को देखना चाहिए अकॉर्डिंग टू द राइटर, जिसमें हमारे एडवांटेजेस गेन कि अगर हम एक पनिशमेंट दे रहे हैं अकॉर्डिंग टू ऑफेंस तो उसके एडवांटेजेस क्या है कि वो ऑफेंसेस ज़्यादा नहीं हो रहे हैं, लोग उस ऑफेंस को करने से रुक रहे हैं. सो दैट इज़ एन एडवांटेज गेन या मिसचीफ अवॉइडेड. When the particular sentence is in question, the first consideration is guilt, without which punishment is a strict sense is impossible. तो सबसे पहले जब हम पनिशमेंट देख रहे हैं उसमें सबसे पहले देता है कि गिल्ट, कि क्या ऑफेंस ब्रीच हुआ है, क्या गिल्ट हुआ है, क्या ऑफेंस कमिट हुआ है. दैट इज़ द नेसेसरी कंडीशन. कहीं ना कहीं गिल्ट होना ज़रूरी है, ऑफेंस ब्रीच बेसिकली होना ज़रूरी है. विदाउट उसके पनिशमेंट देना इज़ इम्पॉसिबल. The second consideration must be the legally prescribed limits within which the penalty must fall. Beyond that, decision must be made in the light of criteria tending to mitigate if not totally defeat the presumption in favor of the maximum penalty. ये फॉर्मल प्रिंसिपल्स ही है जिसका